the panel on the Endangered Species Act. If you're in the wrong place, check your schedule so you can get yourself into the right place. My name is Ted Hadji. I'm the senior attorney for the Center for the American Future of the Texas Public Policy Foundation. Basically, our center, we're a bunch of lawyers, and what we do for a living is we sue the government. So when the government goes askew of the Constitution or legislation or regulations, we hold their feet to the fire, and we make sure that they comply with the law just like the rest of us do. That's what's called the rule of law. And we make no distinction between federal, state, and local government. When any of them violate the provisions of law, we will go after them. And we try to make sure that they know now and in the future that that's why we're here. So this panel is sponsored by our Center for the American Future, and it's also sponsored by our sister organization at TPPF, Life Powered. And Life Powered, the project is designed to ensure energy reliability and a balanced approach to energy use and development. So having said that, I just want to introduce the Endangered Species Act. How many of you in the audience are basically familiar with the general provisions of the ESA? Okay, a good number of you. So I'm going to keep my introductory remarks short. I think that all of us can agree that the basic purpose and goal of the ESA is a good one. It's praiseworthy, and that is that species are interdependent. There's a symbiotic relationship between the human species and other species. We depend on them to live, and they depend in large measure on us. And so that's why the ESA was enacted in the early 1970s to ensure that species do not become extinct. Great goal. The problem is that Congress in the early 1970s didn't anticipate the law of unanticipated consequences. In 1978, the United States Supreme Court decided in the case of Tennessee Valley Authority v. Hill that species must be protected, quote, whatever the cost, close quote. And those three words, whatever the cost, have caused the original intent of the ESA to become, quite frankly, perverted. And it's caused countless infringement on liberty rights and private property rights. I'm going to give you an example. There are actually two programs in the ESA, which many of you are aware of: the listing of species as endangered or threatened, and then once those species are listed, they're protected, then there's a designation of critical habitat for that species. Critical habitat is basically the geographic area that must be protected in order for the species to survive, for the species not to go extinct. And it's in that critical habitat area where the most damage to individual liberty and property rights has occurred. Let me give you one example. There's a species on the West Coast called the northern distinct population of the green sturgeon. And what the National Marine Fisheries Service did is designated as critical habitat virtually the entire west coast of the country, from the midpoint of California in Monterey, going all the way north to the very tip of the state of Washington on the Canadian border. That entire coast, as well as all of the rivers associated with the Pacific Ocean going into Washington, Oregon, and California, are now designated as critical habitat for the green sturgeon. So imagine you're a property owner, let's say in the state of Oregon, and imagine that your property extends to one of those river banks. And let's say that your property has some wetlands on it. And let's say that you want to build a fence on your property. Now, all of you should know, in order to build a fence under those circumstances, you need a permit from the United States Army Corps of Engineers. If any of you don't know that, then you probably want to stick around after the panel and talk to me. But assuming that you do know that, It's not simply getting a permit from the Army Corps of Engineers, because if it's designated as critical habitat, the Army Corps of Engineers has to go to the National Marine Fisheries Service and basically obtain from them a biological opinion. And a biological opinion in this consultation among federal agencies can take years to develop and can cost hundreds of thousands of dollars, and in some cases, millions of dollars. And this is where, when you want to build a fence on your own property, or build a pond, or drain a pond, this is where critical habitat really comes into play, infringing on your liberty and infringing on your private property rights. Now, that's why pundits have said that the ESA, in practice, basically destroys individual lives and individual businesses, especially if your livelihood depends on your use of your property. There are three winds of change coming down the pike now. In 2018, the United States Supreme Court decided the case of Weyerhauser v. U.S. Fish and Wildlife Service. That's a huge change, because that's the first time that the court decided, and it decided this unanimously, that all critical habitat designations are judicially reviewable. You may think, well, gosh, of course, something as important as critical habitat to liberty and property rights should be judicially reviewable, but virtually every lower court said that many of the critical habitat designations were not judicially reviewable. Finally, the Supreme Court says they all are. Number two, there are regulatory proposals that have been published in the Federal Register that may give some relief. And number three, there are some pending pieces of legislation in Congress. Unfortunately, some of those pieces of legislation have their own problems in looking at the crystal ball in terms of unintended consequences. But we're going to talk about all three of those developments in today's panel. To start us off with a discussion of the Weyerhauser case is Brooke Wahlberg. Brooke is a partner with the Nossaman LLP law firm here in Austin. She's an expert in the Endangered Species Act and in other environmental laws. She has graciously agreed to sit in for her partner, Alan Glenn, who was unable to join us today. So without further ado, please join me in giving a big-hearted Texas welcome to Brooke.
Good afternoon, everyone, and thanks so much, you guys, for having me speak here. I'm thrilled to be a part of this. I'll warn you guys, I've got a cough drop in my mouth. I'm not sick. I am losing a battle with cedar that makes for an annoying cough from time to time. So hopefully it won't come up in the next 20 minutes, but I'll just go ahead and get that out there. So today I'm going to talk to you about frogs, and as Ted mentioned, this is a perfect example of when the government goes askew. And in the endangered species practitioners world, this case was really exciting because it was finally something square on Endangered Species Act. We really hadn't seen a big Endangered Species Act Supreme Court case in 10 or so years. And let me see, there we go. So I'm going to start with telling you a little bit about the case background. Then I'm going to step back and get into some of the stuff that Ted briefly mentioned about what is critical habitat and why do we really care. And then I'll get back into the Supreme Court's holding and its implications. So the case background is that the service, so the U.S. Fish and Wildlife Service administers the Endangered Species Act. And in response to a lawsuit from environmental organizations, they designated critical habitat for the dusky gopher frog, a little frog that's over in Mississippi. Well, part of their designation included what we're going to term Unit 1. Unit 1 is a 1,500-acre privately owned parcel in the middle of Louisiana. It's actively used for timber operations and was planned for development as well. But it was designated as critical habitat as a part of this greater critical habitat designation that the service conducted. So, as I said, the frog lives in Mississippi and this parcel's in Louisiana. So the frog hasn't been seen in Louisiana in decades, and this particular parish, the frog hadn't been there since the 1960s. And so when you think about critical habitat, you generally think, well, habitat and important habitat if it's going to get called critical habitat. When I explain this case to some of my friends, it's kind of a duh for them. They're like, well, yeah, but that wasn't the case here. Despite the fact that the frog hadn't been in Louisiana or on this parcel, the service still thought it was necessary and essential to conservation to designate this as critical habitat. Part of the reasoning is that there are some ponds on this property, and the frogs like ponds, and they're dependent on ponds for breeding. But what they do is they pick ponds that are near open canopy forests, like in Mississippi, whereas this parcel was all closed canopy forest because of the timber operations, had closely packed stands and things. And so this actually wasn't even an area that the frogs could use if they knew about it. It didn't have the makings of the characteristics that keep them safe and give them food and that sort of thing. And so not only was it unoccupied, it was also not habitat at this point for the frog, and because of the active timber operations and the plans for development, there was also no plan to ever turn it back into habitat. But nonetheless, it became critical habitat for the frog. The service also did an economic impact in accordance with the Endangered Species Act, and they assessed that the economic impact of just this designation on Unit 1 would have $33.9 million in economic impact and lost development opportunities. Now, under the Endangered Species Act, you have the opportunity, the service has the opportunity, after looking at these impacts, to decide, well, let's go ahead and exclude this from critical habitat because the advantages of excluding it outweigh the benefits of including it for the frog. They looked at that and decided 33 million, not habitat, frogs not there, still should be critical habitat, and went forward with the designation. The landowners challenged this, so the landowners, Weyerhauser and a few others. They challenged this designation in the district court, and the district court said, no, we give deference to the service's designations, they're the experts. And then also, we're not even going to look at this question of whether they properly looked at economic impacts and made the proper assessment in their decision to exclude, because that's entirely in their discretion, and it's not judicially reviewable. Ted referenced this just a second ago. Then the district court affirmed the service's decision, refused to hear the economic impacts analysis argument against that, and then it went up to the Fifth Circuit, where the Fifth Circuit similarly affirmed the service's decisions and similarly declined to give judicial review to the economic analysis. So at that, the landowners petitioned for cert to the Supreme Court. So the Supreme Court granted cert on two questions. The first question was, does the Endangered Species Act prohibit designation of privately owned land as unoccupied critical habitat that is neither habitat nor essential to the species conservation? And then the second is an agency determination not to exclude an area from critical habitat due to economic impact of designation subject to judicial review? So with that, I'm going to touch briefly on critical habitat a little bit more in depth than what Ted primed us on, and similarly. So first of all, what is critical habitat and what impact does it have on the regulated community? Why do you care? So first, the ESA and the statute itself defines critical habitat. You don't have to pay too much attention to that definition, but the important takeaway there is that it speaks to having features, being essential to conservation of the species and whatnot, and it makes a distinction between occupied habitat and unoccupied habitat. So the endangered species does contemplate that there will be some areas that are unoccupied that could be essential to the conservation of the species that would qualify as critical habitat. But again, they hold that to a higher standard. It has to be shown to be essential to the conservation of the species. There's regulations that track this as well. That's the regulatory citation. And it had the same thing. Like, here's the definition of critical habitat. You've got occupied, unoccupied has a higher standard. During the Obama administration, I'm not going to get too far into this because Melinda's going to cover a lot of this. The Obama administration finalized some amendments to the critical habitat rules that actually relaxed that unoccupied standard and basically made it more akin to if it was occupied habitat. Those amendments were sued by 20 states and the case settled. And then in July, revisions to the critical habitat regulations were part of these ESA amendments that Melinda will be speaking on. And what they would do is restore that heightened standard for unoccupied habitat that we see in the statute and that we saw in the original version of the regulations. Again, here we're talking about occupied and unoccupied, and in the Unit 1 case, we have unoccupied, but we also don't have habitat. We have unoccupied random area that isn't even habitat for the species as it currently stands. And that's a big point of this case. I forgot to put this slide in, so I'm going to insert it right here. The other thing to remember is where critical habitat arises in the Endangered Species Act. So what you just saw was the definition. Where it arises is in Endangered Species Act Section 4, which is where it breaks down how the service lists, delists, designates critical habitat and whatnot. And the language that it says is that, I'm going to read it here so it's on my slide, is that the service must also designate any habitat of such species which is then considered to be critical habitat. And so again, there's this presumption that when you're designating critical habitat, it's going to be habitat first and foremost to be eligible for such a designation. So this is the provision in Section 4, again, the same section, that talks about economic impacts. And what it does is says the service, when you're deciding whether to designate critical habitat, you can look at the economic impacts, impacts on national security, and all these other relevant impacts, and then look at that. And if you so choose, you can exclude those areas. After looking at these factors, you can exclude any areas that you decide that the benefits of exclusion outweigh the benefits of inclusion. And that's where the service took a look, saw it would be $33.9 million in lost development opportunity, and still thought that the benefits of inclusion outweighed the benefits of exclusion and made that determination. And the lower court in the Fifth Circuit said, yeah, we can't touch that. That's one of those exceptions to the Administrative Procedure Act where it is so in the agency's discretion that we have no meaningful standard by which to evaluate that. So there's no recourse here for you in the courts. Sorry. Okay, so let's talk a minute about critical habitat. I'm actually going to give a very similar example to Ted, and I'll keep it short since you've already heard it once. I won't belabor the point. But it's important to think about how this extrapolates out to on the greater scale. So a lot of times you'll hear critical habitat. People say, oh, it doesn't matter. It only matters on federal lands and federal actions. And you're like, okay, well, I'm private land, private acting. Well, in Louisiana, think about it, there's a lot of wetlands. No matter what your definition of waters of the United States are, a lot of times in Louisiana, you come across wetlands and you're going to need some sort of permitting. And even the streamlined permitting, nationwide permits, if any of you guys are familiar with the nationwide permit program, has a condition that if you've got critical habitat anywhere near your regulated activity, or your regulated activity under the Clean Water Act may affect critical habitat, that you're now thrown into that consultation process that Ted described. So it essentially takes a private action on private land because of a trigger, even through a streamlined permit process, and throws you into another federal process that can have big time delays and also costs through conservation measures and whatnot that typically come up as a result of that process. Take that even further. Think about 1,000-mile-long transmission lines or pipelines. Think about the planning process for those, trying to avoid areas that are ecologically sensitive, trying to avoid critical habitat, trying to avoid things that would trigger various processes to manage your project timelines. Well, if the service continues the trend of designating critical habitat on areas that aren't even habitat and not occupied, it gets awfully hard to plan a project that doesn't run the risk of hitting one of those triggers to consult with the Fish and Wildlife Service. And because of the nature of the service tends to take a pretty expansive view of its jurisdiction. So even if they're looking at one nationwide crossing on mile 10 of your 1,000-mile pipeline, that might be enough for them to say, you know what, we're going to look at all of this habitat that's down here on mile 900 because we think that's in our jurisdiction. And now you have a process that is expanded to your entire linear infrastructure. So it does have potentially huge implications if that practice were to continue. So, back to the case. The Supreme Court, this was the very first oral argument of the fall term. It was October 1st, 2018. Kavanaugh had not yet been confirmed and did not participate in the case. There was some question whether whether his confirmation would then signal a re-argument and whether they would go at it again, but they didn't. The oral argument actually centered a lot on what constitutes habitat. It was pretty evenly split on the 4-4 bench. The landowners argued, well, the area must support a species, like in order for it to be critical habitat, it needs to already be habitat at the very least. The service's argument was, well, okay, it may need to be habitat, but it can be habitat even if it still needs some additional modification to get there. And so a lot of the argument went back and forth on to what extreme do you take that? How much more modification to get to habitat does something need to have and still qualify for habitat? And so that's where a lot of the oral argument focused. The opinion was published on November 27, 2018. It was 8-0 and authored by Chief Justice Roberts. This is significant because if you listened to the oral argument and you read the lower court opinions, you would have thought that you would end up with a 4-4 split or something along those lines, because Rapinos, Sweet Home, a lot of the big natural resource cases ended up being pretty split opinions. This one was 8-0, and I think part of this was based on the, well, duh, it has to be habitat. I mean, that's really what they zeroed in on, rather than focusing on some of the deference questions and that sort of thing that I think would have probably led to more of a split. So the Supreme Court vacated the Fifth Circuit ruling and remanded the case back to Fifth Circuit. So what they said, and obviously I've already ruined this surprise, is that, hey, critical habitat needs to first be habitat to be eligible. And so now the question for the Fifth Circuit is, okay, so the service thinks it can be habitat even if it's not quite there and needs modification. The landowners say it needs to be habitat from day one to even be eligible. Fifth Circuit, you need to take another look at that because you didn't look at that the first time around. The other is what Ted was speaking of, this judicially reviewable question. You know, previously, landowners that wanted to challenge these critical habitat designations that had $34 million impacts on their property and whatnot didn't really have an avenue to do so because the court said, no, 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 that's in their discretion, we can't review it. The Supreme Court heartily disagreed with that. They said, no, this is exactly the sort of thing that we would want to review for abuse of discretion. And the language in that Section 4 regarding economic impact, national security concerns, those sorts of things, gives the courts enough of a meaningful framework by which they can assess whether the agency has abused their discretion, and made clear that most agency decisions are judicially reviewable, and that agency decisions that are excluded from judicial review are supposed to be the far, far exception and not the rule. And this actually continues a trend that we've seen in some of the Clean Water Act cases. Hawks and Sackett were both Clean Water Act cases that went through the Supreme Court, where agency actions that had previously thought to be not judicially reviewable, the Supreme Court said, no, 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 this has profound impacts on landowners and private citizens. This is exactly the sort of thing that we should be able to review, and these are judicially reviewable. So it continues in that trend, and that, again, is something that has implications beyond critical habitat designations. And so one last thing, and then I'll wait till questions and answers and let these guys take the floor. From a standing perspective, there was a footnote in the decision that's also worth noting, and it said that the Supreme Court also noted that the loss of property value that results from the critical habitat designation is sufficient injury to give landowners standing to challenge critical habitat designations. So again, this is a problem that had previously not been favorable to landowners in lower courts, and here very clearly stated, no, 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 you have enough injury here because critical habitat, federal nexus or not, gives you enough injury to have standing to make a claim. So again, another implication there. And with that, I will sit down.
Thank you very much, Brooke. I just want to quickly follow up on the reviewability issue, give a plug to the Center for the American Future. We filed an amicus brief on behalf of the National Federation of Independent Business and the Building Industry Association of the San Francisco Bay Area, arguing that all critical habitat decisions, without exception, must be judicially reviewable because of the severe impacts on liberty and property rights. The Supreme Court unanimously not only agreed with our case, but I'm very proud to say actually took much of our language and incorporated it into their opinion. So that's a very happy moment for the Center for the American Future. Our next speaker is Melinda Taylor. She's going to be talking about some of the recent regulatory proposals to unwind the Obama administration's tightening of critical habitat designations, and also generally to provide some regulatory relief for those of us who are affected by the ESA. Melinda is on the faculty of the University of Texas Law School. She's the senior lecturer and academic director of the K. Bailey Hutchison Center for Energy Law and Business. And she's also a visiting professor at the Strum College of Law at the University of Denver. She used to work for the Environmental Defense Fund and the National Audubon Society, and I think she provides us with a very different perspective on the ESA as she covers for us those current proposed changes. So please join me in welcoming Melinda to the podium.
Good afternoon, and thanks, Ted, and thanks for having me. I was going to joke that I'm the diversity panelist because I do come with a somewhat different perspective on the ESA and a different background. Although Brooke and I worked together at the law firm for a while, 6 months or so, before I left and joined the faculty of UT. But anyway, it's a pleasure to be here today. So this is, in July of last year, the Trump administration proposed really a very robust package of regulatory proposed amendments for the Endangered Species Act. It's by anybody's measure, the most significant set of regulatory reforms that the agencies, that the services have considered in at least 2 decades. But that being said, a lot of these things that the administration is proposing to do are not dramatic changes, really, in terms of how the Fish and Wildlife Service especially has been functioning for the last decade or so. Some are significant, but others not so much. I know that a number of these proposals were actually formulated by service biologists in 2015, 2016, at the end of the Obama administration. So anyway, I just want to sort of temper some of this with that type of framework. That being said, there's some very significant proposals here, and I'm going to try to highlight those as we go forward. Before I get into the specifics, though, let me I have to have this slide in my presentation. I know that many of you in this room are not big fans of the Endangered Species Act, and I get that. There are a number of very legitimate criticisms that I myself have made of the administration of the Act over the years, and that many of you have made. But nevertheless, I think it's important to see at least how the conservation community frames issues around the ESA, because that should sort of inform the thinking about how the debate about these regs is going to go. And, you know, the Act has kept 99% of the species that are listed from going extinct, sort of proving that at some level at least, it's a good safety net for species that are very imperiled. About 100 species are recovering. They have not, a very small number of species have actually been delisted, as you'll see on my next slide, but about 100 are considered to be recovering or close to full recovery. And again, there remains a very strong level, high level of public support for the Endangered Species Act, even among conservatives. So I think while many folks like myself actually who have worked with the business community, we get it, that there are big problems to be had. Just generally speaking, the public remains strongly supportive of the goals of the Endangered Species Act. Now, that being said, you know, here's the flip side, right? And this is what we're hearing a bit more of these days from the administration. There was a congressional hearing a few months ago, and a lot of hay was made, if you will, about the point that only about 50 species, or fewer than 50 species, have been removed from the list. So the notion that they're being brought to the emergency room, but they're not being released sort of fully healed, that's a criticism. Just generally speaking, we're hearing it today, and I think, again, with a lot of legitimacy, that the law costs a lot, it impedes development, it slows down projects, it makes things very complicated and cumbersome. That's a legitimate criticism. There's this more philosophical complaint that's based on really the history of wildlife law in the United States, that the role of wildlife protection really kind of belongs with the states, right? That it shouldn't be dictated or managed by the federal government at all, that it's really more appropriately in the realm of state government responsibility. And then finally, that the law, the way it's structured, ends up discouraging conservation on private lands. And I'll say a little bit more about that as we go through these proposals, because That's something that I feel very strongly is a absolute apt criticism. I mean, the Act does not do nearly enough to encourage, incentivize all sorts of private landowners, whether they're, individual homeowners or timber managers or agricultural interest or what have you, to do more to conserve rare species. And without that private involvement, the many, many species on the list have no chance of recovery. Now, unfortunately, the regulatory package that has been out for public review and that the Trump administration is finalizing now doesn't really address that private land issue in any significant way. There's nothing really bold and dramatic that's designed to encourage recovery of species or incentivize recovery or private management or conservation actions. So I think that's a missed opportunity, but maybe going forward we'll see something from the administration that would move us in that direction. I won't dwell on this, but my point here is that the Endangered Species Act has become a partisan issue. It wasn't always so. That may be because Congress didn't understand the full sweep of the law back in 1973 when it was enacted, or it may be a result of a lot of different factors. But for whatever reason, we see routinely now lots and lots of bills introduced every legislative session in Washington to either weaken or amend the act, and that's a relatively recent phenomena. It just hasn't, it's up until the last decade, it has not been nearly as partisan an issue as it's become. And I personally think that's unfortunate because it's hard to reform something when the sides are so dug in. Okay, so what's going on now? We've already talked about this. Brooke just talked about Weyerhauser. Ryan's going to talk about the legislative changes. I'm going to spend the rest of my time talking briefly about these proposed rule changes. So there are 36 proposed amendments in all. I would venture my characterization, and I'm not alone in this, is about half of those are really substantive, and the other half I would call bookkeeping or administrative type amendments. And even of the substantive requirements or reforms, some are, again, more dramatic than others. Many of those, even substantive reforms, are things that are basically codifying practices that the Fish and Wildlife Service or the National Marine Fisheries Service have been engaged in for at least a decade. The four main areas that the rule changes address, the substantive rule changes, are first, the decision about whether or not to list a species, and clearly that's significant. Second, these critical habitat questions, some of which actually were dealt with by the Supreme Court in Weyerhauser. Third, there are a number of proposals related to the consultation process under Section 7. And then finally, and to my mind, maybe the most significant revision is the proposal to remove the so-called blanket take prohibition for threatened species. Before I go on to the rest of my slides, I want to just mention the consultation process here because I don't have a separate slide that deals with consultation. The consultation proposals that are being proposed, or amendments that are being proposed, are actually, for the most part, from my standpoint, could lead to much more efficient consultation process and actually conservation benefits as a result. I mean, currently the services do about 11,300 consultations a year. That's been the rate that they've been doing them for the last 8 or 9 years. And so they spend an enormous amount of time and agency resources doing consultations. And anything from my point of view that streamlines that shortens the time frame, that reduces the administrative burden both on the agency and the regulated community and the action agencies is potentially a good thing because it leaves the Fish and Wildlife Service and the Marine Fisheries Service more time and resources to spend on actual conservation measures and not just sort of administrative processes. So the reforms that have been proposed deal with streamlining the consultation process. So that would enable the agency, Fish and Wildlife, for example, to rely more on data that's provided by the action agencies, whether it's the Corps of Engineers or the Federal Aviation Administration or what have you, and not have to kind of reinvent the wheel in various consultation processes. It would shorten the time frame for projects that are deemed to have a a beneficial conservation value, which again would be, makes sense, it's logical, and could definitely move things along, and would just generally enable or reduce the amount of paperwork required to initiate consultations and sort of satisfy the consultation process. With respect to listing, one of the proposed changes that there's been a lot of press about is the agency is proposing to include information about the economic impact of listing in its listing documents. Now remember that the Endangered Species Act has a list of criteria that the agency has to use in deciding whether or not to list a species as threatened or endangered. And economics is not on that list. The agency is supposed to make that decision based on the science and what the science tells the agency the status of the species is. But the service is proposing to include some analysis of the economic impacts of listing in the Federal Register in the listing materials. Now, in the preamble to the proposed reg, the service says, look, we know we can't consider economics in the listing decision. We don't intend to, but we just think it's the right thing to do in the name of transparency and so on to get the information out there. So they're proposing to do that. Whether or not this is actually going to affect the agency's decision-making, I think it's just too early to tell. And I frankly think that some of the negative editorials around the country have been misleading in describing this as being, this catastrophic development on the part of the Fish and Wildlife Service. But in any event, that's out there. In addition, the other listing proposal proposal related to listing that's important is that with respect to threatened species, the definition of a threatened species is one that's reasonably likely to become endangered in the foreseeable future, right? And so the agency is now going to add a definition of foreseeable future that, again, essentially codifies what the Obama administration was doing and the Bush administration before Obama, and requiring that foreseeable future window be based on basically replicable good science and not on speculation. But it sort of gets to the notion of climate change and the extent to which the impacts of climate change might affect the agency's decision to list or not list a species. And again, both the Obama administration and the Trump administration have held off listing some species based on purely climate impacts, relying on this notion that we can't be reasonably certain that in the foreseeable future the species will decline because of climate impacts. So again, I would argue it's a significant amendment, but it's not a dramatic change in terms of what the agency has been doing. I'm not going to spend a lot of time on this, but essentially the proposed rule, and Brooke mentioned this, would give the agency the opportunity, going back to that statutory definition of critical habitat and when unoccupied critical habitat can be deemed critical habitat. This would give the agency the chance to say that if a lot of restoration or management is going to be required in order to make that habitat suitable for the species, then the agency can decline to include that unoccupied habitat as part of the critical habitat designation. The regs would also require that the agency look first at occupied habitat and do an evaluation of occupied habitat before including unoccupied habitat in the designation. Finally, on the blanket take prohibition, very quickly here because I'm about out of time, but since 1975, the Fish and Wildlife Service has had a regulation on the books that extended the take prohibition to threatened species in the same way that it applies to endangered species. Now, the service over the years has issued a number of so-called special rules for threatened species, and they've used those special rules to kind of craft circumstances and plans where certain types of activities, even if they harm the species, would not be an illegal take of the species. National Marine Fisheries Service has never had that blanket take prohibition in place. For a long time, industry advocates and developer advocates have said, why does the Fish and Wildlife Service have a take prohibition that applies to everything if the National Marine Fisheries Service doesn't? Is there something wrong with how the Marine Fisheries Service is running things? And now the service is saying, you know, you're right, let's make it consistent, and let's remove, going forward, for species listed from here on out, that automatic take prohibition. Unfortunately, I think this one leads to a lot of litigation. I think you're likely to see environmental groups litigate, primarily over the listing decisions, even to a greater extent than we have now, right? So environmental groups are going to litigate, claiming that threatened species really ought to be considered endangered. Industry groups will say endangered species really ought to be threatened, and the distinction between those two has never been entirely clear. There will be, I would expect, petitions to downlist species that are currently listed as endangered, because why not? You know, let's try to get them threatened, and then the blanket take prohibition won't apply, and the whole world looks very different. And then these other sort of negative incentives from my standpoint. There will be less of an incentive to include threatened species in safe harbor agreements or habitat conservation plans or just large-scale sort of state-level conservation efforts. And that's it. I'll stop now, and I'm happy to look forward to your questions during the Q&A period.
Well, thank you very much, Linda. And for those of you who are familiar with reading Federal Register notices on proposed regulations, Melinda really did an excellent job of digesting many, many, many words into a format that I think was very understandable and approachable for all of us. Our next speaker is Ryan Walters. Ryan is an attorney with TPPF Center for the American Future, where he practices in the area of constitutional, environmental, and administrative law, with an emphasis on protecting private property rights. Ryan previously served as Assistant Attorney General with the Office of the Ohio Attorney General. And we thank Ryan very much for agreeing to fill in for Kathleen Hartnett-White, who is unable to join us today. Ryan is going to discuss pending legislation in the U.S. Congress to amend the ESA and how that legislation informs our judgment, both with regard to the Weyerhauser case and some of the proposed litigation. Now, who knows when, if ever, this pending legislation, there's a bunch of it, is going to pass both houses of Congress. And Ryan will get into the details, but some of this legislation is not necessarily a step forward in terms of the administration of the ESA. So please join me in welcoming Ryan to the podium.
Thanks, Ted. So Ted mentioned pending legislation, and as you know, the new Congress has just been sworn in, and given the very different makeup of the incoming Congress compared to the last one, a lot of the, I think we can discount the probability of a lot of these bills seeing the light of day out of the U.S. House of Representatives. In fact, even during the last session of Congress, there was nothing of significance that passed both houses of Congress. There was some movement that some bills that passed the House of Representatives, some that just got out of a committee, and some that were just introduced and had a hearing in committee and never even got a vote in the committee. But I think there are two categories of bills that we've seen that I think will, as I'll go into describing some of the exemplars of these two categories that were introduced, and it'll be a good stepping off point to looking at what are the problems that these bills are trying to address. Do they really address some of the fundamental tensions within the Endangered Species Act, and do they is there something further that is not being addressed by these bills that would address the more fundamental problems with the law? So, as has been discussed, there's obviously a very good intent behind the Endangered Species Act. People want to protect endangered species, but there are also interests on the other side. So these two categories of bills, the first category that we have is very targeted legislation to particular agency actions, primarily listing decisions. So when a species is listed by the Endangered Species Act, there's obviously a lot of restrictions put on landowners' conduct surrounding that species. And so Congress has delegated authority to the agencies to deal with the endangered species, and it sometimes is not happy with the particulars of the exercise of that delegated authority. So Congress, particular members from the affected states of particular species that are listed, will introduce bills in order to claw back some of that authority and use a sort of whack-a-mole method after the fact, sort of ad hoc addressing these perceived problems with what the agencies are doing. So, and then there's the second category would be a broader procedural reform of what the agencies are doing with various processes, particularly the listing processes, which is where most of the action is, of listing particular species as endangered or threatened. So in the first category, we have a few examples that I'd like to discuss. So one very simple example, there was a bill introduced, none of these became law, but there was a bill introduced that would prohibit the agency from listing any freshwater mussels as endangered species. Now, in Texas, this is of interest to us here because there is discussion of a lot of our rivers have various species of freshwater mussels that are being considered, that there's some move afoot to put them on the endangered species list. And given all the water issues in Texas, this would affect, if they were put on the list, it would affect drawing water from rivers where these mussels were, and it would affect agriculture and a lot of other uses here in Texas. So this would just prohibit any future listing of any freshwater mussels by the agency. Now, I don't think there's any problem with this sort of ad hoc bill. It's not what you would ideally have. Ideally, I think the Congress would take more responsibility up front and follow scientific inputs from the expertise of the agencies, but make the initial decisions itself rather than just trying to come back after the fact, which is usually not very successful. And this is ultimately, it is a policy question. So as was mentioned, the agencies are not permitted to factor in any sort of economic considerations when it makes listing decisions. So it can, on later decisions surrounding critical habitat, it can use those considerations in its formulation of critical habitat plans. But at the initial stage of listing, which at that level, at the initial listing, it does immediately put restrictions on people's conduct toward those species. So a next level is another bill that's targeted the gray wolf in the upper Midwest and the Great Lakes region, Michigan and Wisconsin. The population there, the Obama administration in 2011, the Fish and Wildlife Service had delisted the gray wolf that it had recovered, and there was a need for, a perceived need for some controlled hunts because wolves had been preying on ranches and farms in the area, and they were seen as recovered enough to be taken off the list. So in 2011, the Obama administration did so, but there was an immediate lawsuit, and a court of appeals overturned that decision. And so there was a bill introduced to reinstate that decision and then bar any future judicial review of that decision. Now, we'll talk about more controversial restrictions on judicial review as we get into some more of the procedural legislation. But I actually think this sort of bar on judicial review and this sort of targeted legislation is not problematic. And I say that because these decisions are ultimately supposed to be made by Congress anyway. And any sort of procedures put in place on the agencies are because of what Congress is doing. And the fact that Congress could have just on its own passed a law saying gray wolf is not on the endangered species list. That to me it means that the agency wouldn't have to be involved because Congress would be exercising the power it's supposed to use anyway. So that didn't go anywhere either. So there is so that delisting of the gray wolf is been overturned by the Court of Appeals and is still in that stasis. Then there was an additional, the final one in this category that I'll talk about is a grizzly bear population around Yellowstone National Park. Now, it's the greater Yellowstone area. It's not in the park itself, which even if this species would be delisted, you would not be able to harm or hunt grizzly bears within the park itself, but it's the surrounding area. And most of the scientific evidence is that this population has recovered. And in 2007, the Fish and Wildlife Service delisted it, but there was litigation, and a court of appeals at that time overturned it, said that the agency hadn't did everything it needed to, hadn't looked at everything it needed to look at. So in 2017, the Trump administration went through the process again, delisted the grizzly bear, and another district court overturned that as well. So this is a bill to reinstate the delisting and bar further judicial review, sort of similar to the gray wolf. Now, the second category, which is a broader procedural reforms of the Endangered Species Act, there are three bills I want to look at. One is, first I need to talk about a little bit more about the process of listing. So the Endangered Species Act, it allows any group or individual to file a petition with the agency to list or delist a species, and the agency has to, within 90 days, determine whether there is any substantial evidence in there, and then it would move on to a 12-month thorough review evaluating the scientific evidence, whether the petition should be granted and the species listed. Now, these deadlines are very strict, and there is no exception to them, and there are lots of petitions filed, and the agency almost never meets its 90-day deadline. And it only meets maybe 4 to 12% of its 12-month deadlines, because there are two groups, mainly two environmental groups, that file 90% of these petitions, and they have dramatically increased over the last 15 or 20 years in how many petitions, and the agencies just can't handle the volume, and they have to deal with these petitions. The Fish and Wildlife Service, under the Obama administration in 2011, asked Congress to put limits on what the agencies had to do. And these provisions are enforced by citizen suit provisions, where any group can then file a lawsuit because of the failure of the agency to meet these statutory deadlines. And so what happens is, you've probably heard of the controversy over suing and settling. You've had a lot of situations where environmental groups would file a lawsuit, and it was perceived by some as a sort of collusive against the Obama administration, where they would file a lawsuit alleging these violations of the statutory deadlines, and the administration would give in after the lawsuit was filed, settle, so they didn't have to go through the time-consuming process. So there's a bill called the Petition Act that would allow the agency to declare a petition backlog if there's a particular ratio of volume, and to suspend these deadlines so that they could deal with in a proper order and the other responsibilities of the agency without just having to go through the settlement process with these environmental groups. Now, there's Senator Cornyn also has a bill to reform that sue and settle process that would require the involvement and expedited intervention of any affected groups, states, and require their consent and approval of any settlements to make sure these interested groups' views are seen and heard before the agency and these environmental groups would impose these regulations. Now, I think these bills don't really get to the meat of the issue. I think the more fundamental problem with the Endangered Species Act is that there is it relies on an old-style command and control regulation from the 60s and 70s. It is no longer seen as the best way to do this. Private landowners are obviously very important to preserving the species, and because their property values will drop if they're not allowed to develop or act on their land, and there's found endangered species on them. This provides a perverse incentive to these landowners to not want these species on their land, so they might make it not attractive to endangered species. So if you compare to, say, wetlands incentive programs, they're a lot more cost-effective. They've been, it's something comparable to what this would do. It would, instead of just putting all the burden on particular landowners who might have the bad luck of having a particular species on them, it would require taxpayers to pay compensation for the protection of these species, and buying up particular lands for habitat, which is the primary threat to endangered species, and the like, would be something that would be more cost-effective and fairer, because it would spread out the risk and burden of this public benefit and put it on the public through the taxpayers. So I think that these bills, while well-intended, they don't get to the nub of the problem, and a more fundamental approach, rethinking of our approach to endangered species that is both better for protecting endangered species and fairer to property owners is something we need to consider. Thank you.
Well, thank you very much, Ryan. We do have time for Q&A. There are going to be one or two people with microphones on either end. So if you'd like to ask a question, just raise your hand, and please take this opportunity to ask the experts and get the benefit of their expertise. Yes, sir.
So the first question over here, and Professor Taylor, thank you for joining us. Thank you to all the panelists, but Professor, especially for bringing your viewpoint here today. I think it was candid, and I certainly received it well. What I wanted to ask you, and then comment for the other panel, is, you know, in some ways, when you adopt a law, it's assuming the worst case scenario. You have to put in a law because otherwise then people would do what you're trying to regulate with the conduct. And I think in some ways, maybe back when the Endangered Species Act was adopted, it was, look, we don't have this, people are going to come out and kill everything that's on the face of the earth. I don't think that's true today. I won't argue about when it was adopted back then. But at a high policy level, is regulation of every species really a role for the federal government? When we had the Endangered Species Act, it was really the grizzly bear or the bald eagle, but 2/3 of species listed under the Act are species that only exist in one specific state. And, you know, if we didn't have the Act, we would still have states who could protect. We would have local communities. We would have private property owners who I think can serve their own resources. And as part of that is maybe one of the reasons why the Endangered Species Act is so contentious, is because it is so intertwined with some very obscure and species that are way beyond of what we think of, you know, a national role for the federal government. So is it time to rethink that? I'd love to get your thoughts. Thank you.
Yeah, it's a great question. There's a lot in that question. So there are currently, I think, 1,600 and some odd species. Is that the list that are on the list, right? So, and that's out of 20,000, 30,000 species in the U.S. So it's not, I mean, there's, in terms of the number of species that are listed as a proportion of all the wildlife and plants that occur, say, in North America, it's still a fairly small number. Now, I understand, I mean, clearly for decades, one of the flashpoints in the ESA has been those species that occur just in one state. You know, there's been a lot of litigation about that question Is the act constitutional as applied to those species that occur only in Texas or only in Alabama or what have you? And also, you know, a good criticism that when Congress passed the act in 1973, they didn't necessarily envision arthropods and, you know, tiny insects being on the act. They really were more concerned with the big megafauna and the big species that they could see were declining. I personally would love to see the Endangered Species Act amended in a constructive way. I mean, no question. I think there are clearly areas that need a brand new look. I think the act has gotten incredibly complicated in its application and administration. So you're not going to get an argument from me about that. I think the problem, though, it goes to the slide that I showed you about the partisanship of it. It's like so many other issues that the United States is grappling with now. The two political parties and the people on either end of those spectrums dominate the debate, and people, you know, the left has trouble trusting the right that if we open up the Endangered Species Act to some sort of substantial reform, we're going to end up with something that actually is good for species, you know, and also results in efficiency. I mean, there's just sort of this mistrust in this sense that, you know, the guys on the right want to undermine all protection, which I know is not the case. So I think at a policy level, I can talk about reforms that I think would make so much sense, but unfortunately, I'm not sure that's going to happen in the near future, you know? So that's not a very satisfactory answer, but I will agree with you that the act does need some reform, and I would love to see some constructive dialogue. And just the last thing, but when I was at EDF years ago in the early 2000s, late 1999 and then early 2000s, there was a very substantial effort to try to reform the act with environmental groups at the table. Georgia Pacific was a key industry player. National Association of Home Builders participated for a while. And a set of reforms was put together, and it went nowhere, even back then, because there was so much kind of mutual, you know, mistrust and distrust of the other side, which is really unfortunate from my standpoint.
Any other responses from the panel?
I would say Senator Mike Lee of Utah did introduce a bill to limit the ESA to interstate species and to exempt intrastate species only found within one state. That was in response to a ruling by the U.S. Court of Appeals for the 10th Circuit that upheld against the Commerce Clause challenge, that argued that it exceeded Congress's authority to reach purely intrastate species that involved the Utah prairie dog. But the Court of Appeals there said that it did not exceed Congress's power, but in response to that, Senator Lee introduced his bill to exempt species found only within one state. I think it would address some of the problems with the huge backlog of petitions for listing of species that have been at the federal level, where it seems like most of what they're doing is just listing species. They're just responding to this massive backlog. And if they could focus instead on a more limited subset of species, they would have more time, the federal agencies would have more time and resources to focus on those particular widely dispersed interstate species and developing methods and programs to actually conserve them.
I was just going to say, this actually makes me think of a frog. You know, the frog, when it was listed, only existed in Mississippi, though it used to exist in several other states. And part of the reason you got into this whole Unit 1 thing is they were trying to introduce some genetic diversity by putting another population further afield to give the species a better chance to survive. And so there's these weird instances where at the time that they're listed, they're in one state, and there actually is a case for moving them around where they used to persist, so that they can actually be conserved. But I think the way to do that is to encourage, and this goes back to one of Melinda's first points, is to encourage private conservation efforts rather than, you know, I mean, I almost view the critical habitat designation as almost like an eminent domain move by the Fish and Wildlife Service to just go into land in the middle of an active timber harvest and designate that because it has some things rather than working on a more voluntary conservation incentive side of things.
Thank you. Any other questions from the audience? Yes, sir, over here.
Yeah, I'd like to ask the panel, whether they think there's any need for reform in the current situation, which finds that fossil fuel companies are heavily fined for interfering with migratory bird patterns and other things, while the wind industry, which slaughters thousands of birds, including eagles and bats on a monthly basis, are giving a free pass.
So I spend a lot of time assisting wind energy and transmission and pipelines and endangered species and bald and golden eagle protection acts compliance. And I think it depends on where you're at and who's around, how the enforcement of those acts comes down. And so there's been a lot of movement within the Trump administration to actually back off of Migratory Bird Treaty Act enforcement across all industries and just say, look, the Migratory Bird Treaty Act is only intended to go for direct hunting, shooting birds for fashion, that sort of thing. It was never meant to go for oil and gas equipment where the birds get caught in the heater treater and that sort of thing. Those original big MBTA enforcement cases, that was never what it was extended to. So there has been a movement towards that, and I think we're going to continue to see more over the next year or so.
Okay, thank you. Other questions? Yes, ma'am.
Thanks so much. So just on the urbanization of say, these areas like Dallas, and there's a property owner that has a parking garage, and Mexican free-tail bats decide to come in and roost, and that is his form of income. And so now he can no longer make money because people can't park there. He can't even shoo the bats away because they've decided to roost there. How is that treated? And it may relate back to, you know, he's still paying property tax, but his value, I'm sure, is depleted greatly. But how is that situation addressed in the current law the way it stands?
Great question. Melinda, you want to look at
I
that?
don't think the Mexican free-tailed bat is a listed species.
Anymore, or
I don't think it's
Hasn't
ever
been
been
yet.
listed.
Okay.
Yeah. So I don't know where that restriction is coming from, whether that's maybe, is it the city? of
it's an older case, but
Yeah.
in general, some species moves into
Right.
a place where someone has a business, that's their form of income,
Right.
and they have no way to shoo that you know, they don't want to kill it, they just
Right.
want it to move on to another place. How is that addressed in the current law?
Yeah, and that's actually a fantastic question when you sort of globalize it like that. So Fish and Wildlife Service does have a policy called Safe Harbor that would give private landowners the ability to, but it requires going to the Fish and Wildlife Service to get a permit, but to say, look, we don't currently have habitat for whatever, the diddly bird or whatever it is that's listed, but we don't have any diddly birds on our property. We have good habitat for it, but we don't have birds yet. Can we get some relief from you prospectively? Oh, sorry.
Can we get some relief from the agency prospectively if we continue to manage our property in a way that's really great for this bird, and then but we inadvertently get the birds, and now we have restrictions? And so the Safe Harbor program is designed to deal with that, but there is an administrative burden associated with that because you don't get that free pass unless you go to the trouble to go to the Fish and Wildlife Service and get it. So, but that issue you're touching on with really the most, for me, the most important shortcoming in the Endangered Species Act is the fact that we don't incentivize, and Brooke just said it too, you know, encourage private landowners, go ahead and replant those longleaf pine trees, or, you know, reestablish that wetland or whatever it's going to be, because if you do that, you're doing something really good for society, all of us that care about biodiversity, and we're not going to penalize you by making you go through a regulatory hoop later. We don't have that figured out yet, and I think that's a huge shortcoming.
Well, folks, as you know, time flies when you're having fun, and they're going to be kicking us out of this room shortly. But thank you so much for your participation and for your attention. And let's once again thank our distinguished panel for participating.